The archival record of professional bowling governance contains a reference that keeps appearing, an antitrust dispute, mid-1980s, often narrowed to 1986. You search for the federal docket. You look for the judgment. You look for the consolidated case file with the PBA listed as a defendant. It is not there, not in the way you would expect it to be. What you find instead is a pattern. Fragments in governance minutes, references in trade reporting, secondhand recollections from people who were in the room. When you align those fragments, they point towards something specific. A regulatory structure where rulemaking, sponsorship, and equipment approval were not independent systems. They were interlocked. And in that structure, liability does not always appear in court records. Sometimes it disappears into procedure. That is what this investigation is about. The central claim in circulation is straightforward. A formal antitrust action involving the Professional Bowlers Association emerged around 1986. The problem is not that no legal pressure existed. The problem is that no single, verifiable, consolidated case file has been located in standard federal or state legal archives under a clearly defined caption naming the PBA as a defendant. You can search. I have searched. The case, as commonly described, does not consolidate publicly. What can be established is narrower than the claim. The 1980s contained multiple legal adjacent disputes involving professional sports governance and antitrust theory. The central debates concern eligibility restrictions and commercial access. Who controlled who could compete? Who could be removed from competition and on what grounds? These were live questions across multiple sports in this period. Bowling was not immune. Governance at the time was split across two primary institutions. The Professional Bowlers Association controlled the professional tour. The American Bowling Congress governed sanctioned play more broadly, covering amateur and transitional competitive contexts. This split created jurisdictional ambiguity that was not incidental. It was structural. When a dispute arose over eligibility or access, the question of which body had authority was never fully settled. Industry commentary from this period and retrospective accounts from participants suggest arbitration activity, legal consultation, and documented tension around player restrictions and sponsorship-linked eligibility conditions. But these are not consistently preserved in a single court record set. The absence of a consolidated docket does not eliminate the issue. It shifts it. The conflict moves from courtroom to governance structure, and governance structure leaves different kinds of records. The authority structure that produced these fragmented disputes was not an accident of administration. It was embedded in how power was distributed across the sport from its earliest professional organization. By the mid-1980s, bowling operated under a split model. The PBA ran the professional tour, the ABC held sanctioning authority, and equipment manufacturers, which principally Brunswick and AMF, occupied a third position that was neither purely commercial nor purely regulatory. They influenced sanctioned equipment approval. They funded event sponsorships. They held contracts with individual athletes. They were not one thing. They were several things at once, and the governance structure did not require them to be separated. This created a layered authority system with specific consequences. Rule enforcement and event access were not governed by the same entity. A decision about eligibility made by the PBA could produce downstream consequences for ABC sanctioned standing and vice versa. Equipment standards were influenced by testing protocols that involved industry stakeholders with direct commercial exposure to the outcomes of those tests. None of that is wrong, but it's incomplete. What the public record of that period preserves is the organizational chart. What it does not preserve is how authority was exercised across those lines in practice. When one institution could justify a decision as tour policy, while a different institution absorbed the sanctioning consequences, the trail of accountability does not follow a straight line. It branches, and branches are easier to lose. The financial conditions of professional bowling in this period matter. They are not background detail. They are the mechanism. Tournament winnings for most touring professionals in the 1980s were limited relative to what we now associate with professional sports economics. Prize structures existed, but for the majority of working tour professionals, they did not constitute a primary income source. Sponsorship agreements with equipment manufacturers constituted a primary income stream. Ball manufacturers and related brands provided both equipment supply and direct financial backing for select athletes. This created a dependency loop with a specific shape. Athletes required sponsorship to remain tour viable. Sponsorship provided equipment, travel support, and supplemental income. Without it, sustained tour participation was financially difficult. Sponsors required visibility through sanctioned events. Sanctioned events required governing body approval of participants. Governing bodies controlled event access and eligibility. Follow that loop. An athlete who lost sponsorship did not necessarily receive a formal suspension notice. There was no ruling, no public record. Loss of sponsorship could function as de facto removal from competitive participation without a single official governance decision being recorded. The antitrust sensitivity arises at a specific point in that loop, when access to competition is indirectly mediated by commercial actors who are aligned with the regulatory decision makers. The governance structure is no longer operating as a neutral arbiter. It is operating as a distribution mechanism for commercial advantage. That is the structural argument. It does not require a sealed case file to be valid. It requires documentation of the conditions, and those conditions are documented. Equipment approval in professional bowling is not a peripheral governance function. It is central. This is different from many professional sports. Ball composition, surface treatment, and core design materially affect how a ball interacts with a lane surface. In the 1980s, the development of new core technologies and surface treatments was accelerating. The competitive significance of ball technology was increasing in real time, and the approval process that determined which equipment was legally usable in sanctioned competition ran through a technical review process that involved the same manufacturers who were developing and selling that equipment. Brunswick and AMF did not merely supply equipment. They occupied a position at the intersection of product development, athlete sponsorship contracts, and competitive equipment approval pipelines simultaneously. The structural issue is not simply that commercial entities had influence. Commercial entities always have influence. The issue is the specific configuration. Manufacturers were not only vendors in the system, they were stakeholders in rule definition. Regulatory approval decisions had direct revenue implications. When a ball received approval, the manufacturer's investment was validated. When a ball was denied or grandfathered out, revenue exposure followed. If regulatory bodies and manufacturers share overlapping advisory relationships, testing coordination, or personnel movement between sectors, independence becomes difficult to demonstrate in practice even if the formal organizational chart shows separation. The chart shows what the structure was designed to look like. The paper trail shows what it actually did. It is hidden in plain sight. Timing is where structural arguments become evidentiary. Across the 1980s governance environment, multiple rule and eligibility adjustments occurred in close temporal proximity to shifts in sponsorship and equipment development cycles. That observation requires careful handling. Proximity is not causation, but in a regulatory context, proximity that is never explained requires explanation. Equipment standard updates were issued during periods of rapid innovation in ball technology. Eligibility and participation policies were revised in phases aligned with tour restructuring efforts. Public explanations for these changes consistently emphasize competitive fairness and tour integrity. Internal justification timelines are not fully preserved in publicly accessible archives. The investigative question is not whether the individual changes were reasonable. Some were defensible on their own terms. The question is sequencing, whether governance changes preceded or followed commercial sponsorship realignments, whether policy justification was documented contemporaneously or retroactively formalized, whether affected athletes or sponsors were identified in official communications at the time of implementation. In a fully transparent regulatory system, timing alignment is explicitly documented. The deliberation record shows what was considered by whom, on what date, against what commercial backdrop. In the bowling governance record of this period, that documentation is incomplete in publicly accessible archives. What exists is the outcome. The process that produced it is partially reconstructed from secondary sources. The two events, rule changes and commercial realignments, sit on the public record. They have never been connected. The PBA never asked why. Sports governance disputes outside major professional leagues have a structural characteristic that distinguishes them from conventional commercial litigation. They do not typically resolve in federal court. They resolve in arbitration. In the bowling governance ecosystem of the 1980s, player eligibility disputes were handled through internal PBA mechanisms or affiliated review structures. Commercial disagreements tied to sponsorship or equipment standards could be resolved entirely outside public litigation. Settlement terms, when reached, were not consistently published. In many cases, they were not published at all. This creates a specific form of institutional opacity. Arbitration outcomes may exist without any public docket visibility. Internal rulings may not name all affected parties. parties. Settlement agreements can resolve disputes without establishing precedent and without generating any public record that can be retrieved through standard archive searches. This is the primary mechanism by which an antitrust dispute can exist in functional terms without appearing as a fully documented case. The dispute happens, it resolves. The resolution disappears into a settlement agreement that no one is required to disclose. What remains visible are downstream effects, rule adjustments that follow, eligibility reclassifications that appear without stated cause, sponsorship changes that occur without public announcement, governance restructuring that is explained in neutral administrative language. The adjudicating record is absent, the effects it produced are present, and if you know how to read governance documents, you can see the shape of the pressure that was applied even without the filing that applied it. Over time, governance institutions do not preserve conflict, they preserve continuity. In the bowling governance record across the late 20th century, the pattern is consistent. The formation of the United States Bowling Congress in 2005 consolidated multiple predecessor organizations, including the PBA's broader governance relationships, the American Bowling Congress, the Women's International Bowling Congress, and the Young American Bowling Alliance into a single entity. That consolidation was presented as administrative modernization. It was also an archival transition. Materials from predecessor organizations are not uniformly digitized. They are not uniformly accessible. In many cases, they are not uniformly preserved. Hall of Fame records document competitive achievement in high detail. Governance disputes are recorded inconsistently. Commercial or legal conflicts from the pre-consolidation period are often absent from public-facing institutional narratives entirely. The effect is not necessarily deliberate deletion. Institutions do not typically destroy records to hide wrongdoing. They preserve what aligns with institutional continuity and allow everything else to deteriorate through neglect, transition, and the ordinary losses of paper archives that no one was assigned to protect. What survives is what someone chose to digitize. What was not chosen disappears without a trace that anything was lost. The result is a historical record that can tell you precisely who won the 1986 Firestone Tournament of Champions. It cannot tell you what legal consultations preceded the eligibility policies that governed who was permitted to compete in it. If you want to follow that investigation, subscribe to Strikeline Bowling. Every video we make is part of it. This was one story. Strikeline Bowling digs up another one every week. Subscribe. The strongest defensible conclusion at the current point in this investigation is not that a single sealed 1986 antitrust case definitively existed in the conventional legal sense. That specific framing, a unified case caption, a federal docket number, a judgment or settlement with named parties, is not supported by a consolidated, publicly accessible record. If that record exists, it has not been located in standard archive searches. That is not a conclusion that the dispute was fabricated. It is a conclusion about where the record currently ends. What can be supported is structural. Professional bowling governance in the 1980s operated through overlapping authority between tour management, sanctioning bodies, and equipment manufacturers. That overlap was not accidental. It was the governance model. Sponsorship and equipment approval systems created functional dependencies that could influence competitive access without requiring any formal ruling. Dispute resolution often occurred outside public litigation channels through arbitration and internal review processes that left no publicly retrievable record. Institutional record consolidation in subsequent decades reduced continuity of primary governance documents from this period. The USBC never investigated what the predecessor organizations resolved and how. The press never asked what remains unresolved requires continued archival work, whether a specific antitrust filing under a unified case caption existed and was later sealed, saddled confidentially, or simply omitted from commonly indexed archives, whether arbitration records exist that would materially change interpretation of governance decisions during this period. The full internal documentation of rule change, deliberations, and their relationship to the commercial timeline. The investigative boundary is clear. The system is documented. The case file, as commonly described, is not. The record does not confirm a single, clearly defined 1986 antitrust case involving the Professional Bowlers Association in the way later sports litigation is preserved in federal archives. What it does preserve is a governance structure, authority split across competing institutions, sponsorship operating as functional access control, equipment regulation carrying direct commercial consequence for the manufacturers who also held the sponsorship contracts of the athletes who depended on that equipment to compete. Within that structure, disputes did not require courtroom visibility to produce material outcomes. They required only procedural authority distributed across overlapping bodies. He applied without public documentation of how that authority was exercised. The absence of a consolidated docket is not an absence of conflict. It is an absence of transparency in how that conflict was resolved and recorded. The remaining question is not whether governance pressure existed in the mid-1980s. It is how much of that pressure was converted into formal record, and how much was absorbed into institutional procedure that never reached public documentation, not because it was hidden, but because no one in a position of accountability was ever required to produce it. That requirement does not expire. The question remains open, and the archive is still there to be read.